Summary of The Essential Guide to Workplace Mediation and Conflict Resolution. Rebuilding Working Relationships. By Nora Doherty and Marcelas Guyler. What is mediation? Disputes can occur in the workplace for a number of reasons. Sometimes co-workers' personalities conflict, and they simply cannot work together. Other times, colleagues' working styles differ, or maybe a historic spat interferes in the relationship. Conflicts cost firms dearly. While morale and productivity decrease, sick days, customer complaints and delays rise. Mediation is a conflict resolution method whereby an unbiased moderator facilitates communication between those in dispute and leads them toward a solution. Although mediation dates back to ancient civilizations, workplace mediation first became popular in the 1960s. And 1970s as an alternate dispute resolution process that is cheaper than going to court. Mediation is a common tool in divorce, medical and environmental conflicts, and even in international politics. Some distinctive principles set it apart from other conflict resolution processes, including: it is voluntary, disagreeing parties cannot be coerced into participating. Those undergoing mediation retain decisive power in the process. It tries to find a solution. Mediation does not focus on past events, but on future solutions. It tries to settle on an accord that all participants can accept. The clashing parties create the resolution. Mediation holds those who are involved in the argument responsible for coming up with the end solution. The mediator is impartial. The process will not work if the mediator is biased toward one party. To have a shot at success, mediators must demonstrate fairness and mutuality from the outset. It is a confidential method to enable participants to share their thoughts and feelings openly. Mediators must guarantee that anything discussed will be regarded as classified information. All parties must agree to a high level of privacy. Formal legal proceedings can be invoked. If mediation attempts fail, the quarreling parties may take their dispute to the courts. However, no legal proceeding should be in motion while the mediation process is ongoing. The 6-step model of mediation. As a mediator, you should convene private meetings with each party prior to embarking on the conflict resolution process. This gives participants an opportunity to state their cases. Take this time to build rapport with participants, allowing them to air any concerns they have about mediation. Explain the goals and possible outcomes of the process. Once these basics are covered, it is time to begin. Guide the parties through 6 stages. 1. Introductions and ground rules. Set limits and monitor the understanding and expectations of the involved parties. Establish specific protocols. Request that only one party speaks at any given time. Ask that all parties show respect for one another and assert that the meetings are confidential. 2. Summarizing. Both parties explain their points of view. Instead of allowing them to rehash historical grievances, focus their attention on what needs to change. Then sum up their arguments and establish a foundation for subsequent meetings. 3. Discussing the issues. To unveil the underlying cause of the dispute, try to isolate the issues from each individual's needs, interests, and positions. Seek shared ground between the conflicting parties, because this reduces tension and increases the odds of finding a compromise. Avoid creating winners and losers and, instead, try to conjure up a win-win scenario. 4. Communicating feelings. Although participants should not suppress their emotions, disclosing their feelings during the highly charged early phases of mediation could damage attempts to find a resolution. Instead, wait until this phase to discuss emotions. Connecting them to positive future resolutions will promote bonding and may lead to a breakthrough. 5. Idea storming. Projecting positive future outcomes can help people achieve them. Ask, what solutions would work for you, or, if you could imagine a way forward here, what would it be? These questions allow both sides to propose their solutions. 6. Signing the voluntary agreement. This accord should be a specific plan that outlines what improvements or actions both parties need to undertake to move ahead. The participants themselves must draw up the agreement, and they are responsible for making it work. State the agreement in positive terms and outline each party's gains. Ensure that all concerned sign and date the agreement. Tuckman's Team Development Model. When conflict infects work teams, the results can include malicious rumors, backbiting, and downright denigration of others. To alleviate team disputes, a mediator must know the group's position in the typical life cycle of a team. Consider Dr. Bruce Tuckman's team development model, which outlines the various phases of a team's lifespan. 1. Forming. Initially, members depend on a leader to make decisions. They want order and security. Members determine their similarities and differences and note them for future alliances. Conformity is powerful and members rarely discuss sensitive topics. 2. Storming. Competition and conflict become evident as the group organizes around a purpose. To fit into the group, people alter their feelings, ideas, attitudes, and beliefs. Fear of failure and fear of exposure shape group dynamics, affecting behavior and causing some members either to leave or to become more vocal. 3. Norming. Members are willing to work together to develop mutual trust. Ideally, communication and creativity are high and the group bonds. However, the team may anticipate future disruption and become resistant to change. 4. Performing. This is the highest level groups can achieve, and not all will reach this advanced level of collaboration and problem solving. Members are self-assured and share a sense of group unity and identity. The group focuses on accomplishments and experimentation. 5. Adjourning. Eventually, a group may have to disband. Mediation at this stage could involve facilitating group members to say their goodbyes or to draw their tasks to a conclusion. The brief mediation model. When disputes arise between customers and staff members, managers need to think fast and resolve the issue on the spot. The brief mediation model is a simple 5-step process. 1. Intervene in a friendly, professional, non-biased way. 2. Listen to both sides of the argument and restate the problem in your own words. 3. Make sure you have understood the problem correctly. 4. Try to come up with a solution that is mutually beneficial for both parties. 5. Encourage both parties to agree to a solution and to confirm that agreement. Case study: the bullying manager. Nicola, a respected manager in a large software firm, lodged a complaint with her company's human resources (HR) department when she felt that her line manager, John, was disrespectful to her in staff meetings and excessively critical of her ideas. As a result, her communication with John deteriorated. Nicola's complaint cited bullying and harassment. HR informed John of the complaint and suggested that Nicola and John undergo mediation. John was surprised by the news, but agreed to the process, as long as it was confidential. The company hired an outside mediator and arranged an off-site meeting. The mediator held separate meetings with each person and found they had different versions of the situation. He then explained the mediation process. Initially, John and Nicola found it difficult to address one another without some answer. Over time, they began to deal with some parts of their problems. They then reached a point where they could break off discussions or agree to proceed. This was a sensitive juncture for the mediator, who had to carefully present the benefits of continuing. Soon, John conceded that he would reconsider how he presented feedback to Nicola. This was a breakthrough, and soon the conversation about better ways to work together in the future increased. The mediation ended with both parties signing an agreement about what they had discussed. A subsequent follow-up meeting and evaluation found that, although they weren't close friends, Nicola and John were working together better than before the mediation. Case study: sexual harassment. Erica lodged a complaint of sexual harassment when she accused her colleague, Robert, of making comments of a sexual nature and putting his arms around her. When Robert was presented with these charges, he asserted that his comments were not meant to offend. He did not understand why Erica was complaining. From an organizational liability perspective, the firm had to take the complaint seriously. Since both parties were willing, the company arranged a mediation session. Robert agreed to avoid any physical contact and inappropriate comments. Erica agreed to inform Robert if she felt he was overstepping his bounds. The case was successfully resolved. Why conflicts arise? Scientists have determined that stress plays a key role in most conflicts. Many stress responses are hardwired in the brain, such as the fight-flight response, the alarm response, and the freeze response, in which a victim becomes inert until the danger passes. These reactions have behavioral and biological origins. The brain's perception of potential harm can trigger stress not only in response to physical threats, but also in reaction to psychological threats that could endanger an individual's needs, values, or identity. In the workplace, people suffer stress when they lose control, become bored, contend with change, or face a challenging situation. Past experience also shapes perceptions. Extraordinary events stretch the mental maps the brain creates to interpret reality. These maps guide people's beliefs, emotions, and behaviors. They help make everyday life predictable and less stressful. Mental maps play a key role in conflict management. Mediators who can encourage participants to share their maps have a better chance of diffusing perceived challenges to each party's individual survival. In the popular book, I'm Okay, You're Okay, author Thomas Harris outlines for situations that describe how people cope with stressful social situations. The I'm okay, you're okay scenario, people acknowledge that they and their counterparts have significant self-worth. The I'm okay, you're not okay scenario, one individual believes the other person is not worthy of respect. The I'm not okay, you're okay scenario, one person believes he or she is worthless and doesn't deserve to be in the company of the other person, who is worthy of respect. The I'm not okay, you're not okay scenario, a person believes that the situation is futile and that everyone is wrong and everyone is damned. The assertion theory can help mediators analyze how four different personalities will manifest themselves in conflicts. An aggressive personality gains control over others by bullying and intimidation. A passive personality seeks to diminish tensions by making peace regardless of the consequences. A passive-aggressive personality appears compliant, but really uses tactics, such as guilt or indirect sabotage, to achieve his or her goals. The assertive personality shows concern and understanding to gain a mutually beneficial solution. In these stressful situations, mediators must work hard to avoid being drawn into the negative psychology evident in so many problems. The entire mediation process is designed to avoid judgmental attitudes while promoting impartiality. Mediators can practice effective listening, evaluating, and fairness only when they view the involved parties as worthy individuals who have a problem that can be resolved by using logical thinking and the 6-step mediation process.